shows if you're inactive or not active, and it shows if you've had any sanctions or you haven't had any sanctions.
Right. And the reason that's important is in order to be eligible to perform appraisals for federally related transactions, you have to be on the registry. More and more, when the registry started, it was nothing but a database. It was before computers were used throughout the industry, and certainly before the internet and the prevalence of information being available on the web. Now what we have is, instead of the registry being kind of a cloistered thing, it's very much out in the public. Most all appraisal management companies, large lenders, large and small, can go to the registry and do go to the registry to check to see if appraisers on their approved list, for example, are licensed or certified, and what their disciplinary history is. We transmit, this is a new requirement from Dodd-Frank. We're required to transmit an annual report to Congress by June 15th of each year. We will be required to maintain a national registry of appraisal management companies. We monitor the work of the Appraisal Foundation, and we also provide grants to the foundation, which we have done since 1992, but now we're also going to be required to give grants to the states. The Dodd-Frank Act, 2,000 pages or so of it, dealt with a lot of financial issues other than appraisal issues. But Title 14 focused largely on appraisal issues, and there are a number of changes regarding appraisals and appraisers that don't directly affect the subcommittee and don't affect Title 11, but certainly are going to have an impact. So there's four acts that were amended by the Dodd-Frank Act, and you're really starting to see some of those changes start to come to the fore. We'll talk more specifically about Title 11 in a minute, but the Real Estate Settlement Procedures Act was amended. The Truth in Lending Act, TILA, was amended, and the Equal Credit Opportunity Act all three of those were also amended. The Real Estate Settlement Procedures Act and the regulators, the Federal Financial Institution Regulatory Agencies, along with the CFPB and the FHFA, are in the process of writing regulations to implement these changes in the law. The Real Estate Settlement Procedures Act, for example, the changes there deal with whether how appraisal fees are spelled out on the HUD-1 statement. I know a lot of appraisers have been hoping that the AMC fee would be broken out from the appraisal fee in some way. It appears that the CFPB, who's in charge of this, chose not to go that direction. It's an option, but if you have comments or opinions on that, I strongly urge you to contact the CFPB and voice your opinion. Truth in Lending Act was also amended, as well as the as ECOA. In terms of the Truth in Lending Act, and I'm assuming you guys have heard about some of these things, so hopefully this is meaningful to you. But the Truth in Lending Act amendments require, it's in regard to high-cost loans and loans that now fit the definition of high cost, what in the past would have been called subprime loans. There are specific requirements in terms of properties that are flipped within 6 months require a second appraisal. Those loans also require an appraisal that includes a walk-through interior inspection of the property. So no drive-bys, no alternate valuation products there. But specifically in regard to the Dodd-Frank Act amendments to Title 11. There had been 25 sections to Title 11. Over half of those sections were amended in one way or another. mostly giving the subcommittee more authority, more responsibility, more work to do, and there were 3 new sections also added. So I'm going to briefly go through what the kind of the highlights are of the changes to Title 11. The first being our meetings. The ASC is now required to hold open meetings. And the subcommittee always had part of their meeting in the open, if you will, open to the public. But now it's required. And any votes that the subcommittee takes have to be in open session. The subcommittee holds its meetings monthly, the second Wednesday of every month. I always encourage people to come to the meetings. Are they the most fascinating meetings that you'll ever attend? Probably not. He's been to a few. But I think it's important for people to, if you have the ability, if you're in Washington on the second Wednesday of a month, come to the meeting. Now, you have to sign up beforehand. You got to let us know at least 48 or 72 hours beforehand, because there is security at the meetings. They're held at the OCC, and we have to get names to their security in order for you to be able to get in. But other than that, you are free to attend, and I think it's always kind of good to see how your government operates. Who pays for the operation of the subcommittee? Somebody said it. You do. We do. I'm an appraiser too. You know, it's your fees that are paying for my salary, paying for the operation, that pays for the grants that we give to the foundation. So it's important that you pay attention to what we're doing for you or to you, depending on your opinion. Yeah. Well, I think we're going to hold the questions till the. If that's right. The ASC was changed in a fundamental way by Dodd-Frank by adding the FHFA and the Consumer Financial Protection Bureau to our board. The Dodd-Frank also authorized the subcommittee to raise the National Registry fee to pay for all this additional work we need to do. The registry fee had been $25 on an annual basis since its inception. I think we started collecting National Registry fees in about 1992, and it had been $25 until January 1st of this year, when it was raised to $40. Dodd-Frank also gives the subcommittee the authority to raise that fee up to $80. Now, keep in mind that part of that money and part of the reason that Congress gave us that authority is to give the money back through the work of the foundation, through grants, and to the states. It's not just to, it's not just to pay for the bureaucracy of the ASC, which we really do try to, as much as we can, to keep down to a minimum. The last one there was grants to the states, and I've already mentioned that. We are required to start giving grants to the states. For the last 3 years, we have been giving a form of a grant to the states through the investigator training program. I think Dave will probably talk a little bit about that, but that's been a very successful program that the subcommittee has funded through the foundation to train state investigators on USPAP and how to conduct investigations appropriately. AMC regulation. As a result of Dodd-Frank, appraisal management companies are being regulated. About 30 to 35 states have already adopted their own version of AMC regulation, and a number of states are in the process of adopting AMC regulation. As of, I'll go into more specifics on that in a minute, but the subcommittees also, once the regulation takes place, the subcommittee will also have to maintain a national registry of appraisal management companies. The caveat here is if you are an appraisal management company that is owned and operated, if you're a subsidiary of a federally regulated institution owned and operated by that institution, you do not have to register with the state under the theory that they're already being regulated at the federal level. Now, they still have to register with the subcommittee, and they still will have to pay the fees that we're going to talk about in a few minutes to the subcommittee.